If someone fails to pay after a closing, the primary recourse is to file a lawsuit for breach of contract. Attaching a lien to the property is not an option, since the person will no longer own the property. To minimize the risk of non-payment, get the payment agreement in writing. Have the person sign a post-closing agreement that clearly states the amount owed, due date, and consequences of non-payment. Insist on a certified check or cashier's check. These types of checks guarantee payment and cannot bounce. Also, have the payment cut directly from the proceeds. This ensures that the payment is made before the person has access to the funds. This can be requested through the closing attorney or attorneys. Accepting a post-dated check is risky because the person may not have sufficient funds in their account on the due date. If you do choose to accept a post-dated check, make sure to deposit it immediately to minimize the risk of a stop payment. Follow up with the person before the due date to confirm that they have funds available. The safest option is to have the payment cut directly from the proceeds at closing. This ensures that the payment is received promptly and eliminates the risk of the person failing to honor a post-dated check or simply refusing to pay after the closing. Understanding the different types of checks is important in financial transactions. Firstly, a personal check is a paper document instructing a bank to transfer funds from the payer's account to the payee. It's convenient, but relies on the payer having sufficient funds and can be subject to fraud. Secondly, a certified check is a personal check guaranteed by the bank. The bank verifies the payer's account has sufficient funds and sets aside those funds, ensuring the check will clear. This provides greater assurance to the payee compared to a regular personal check. Thirdly, a cashier's check is issued by the bank itself, drawn against the bank's own funds. To obtain one, the payer provides the funds to the bank and the bank issues the check. This is considered a very secure form of payment, as it is backed by the bank's financial resources. As for post-dated checks, these are checks written with a future date. They are essentially a promise to pay at a later time. While they can be convenient, they carry the risk that the payer may not have sufficient funds when the date arrives, or may issue a stop payment order. Laws regarding post-dated checks vary by jurisdiction. Wiring money involves electronically transferring funds from one bank account to another. It's a fast and secure way to send money, especially for large amounts or international transactions. However, it's important to verify the recipient's information carefully, as wire transfers are difficult to reverse. Money orders are another payment option, often used by individuals who don't have bank accounts. They can be purchased at post offices, banks, and other locations. The payer provides the funds, and the money order is made payable to the recipient. Money orders are generally considered safe, but it's important to keep the receipt as proof of purchase. Each payment method has its own advantages and disadvantages in terms of security, convenience, and cost. Choosing the right method depends on the specific situation and the level of risk involved. When receiving payments, consider the following tips. Firstly, verify the payer's identity. Request identification to ensure the person making the payment is who they claim to be. Secondly, use secure payment methods. Opt for certified checks, cashier's checks, or wire transfers, especially for large amounts. Thirdly, be wary of overpayments. If someone sends a check for more than the amount owed and asks for a refund, it could be a scam. Fourthly, deposit checks promptly. The sooner you deposit a check, the less likely it is to bounce or be subject to a stop payment order. Fifthly, keep detailed records. Maintain accurate records of all payments received, including dates, amounts, and payer information. To avoid non-payment, firstly, get it in writing. Always have a written agreement outlining the terms of payment, including the amount owed, due date, and any penalties for late payment. Secondly, request a deposit. For large transactions, consider asking for a deposit upfront to ensure the payer is committed. Thirdly, send invoices promptly. Send invoices as soon as possible after providing goods or services, and follow up if payment is not received on time. Fourthly, consider using a collection agency. If you're having trouble collecting payment, a collection agency can help recover the debt. Fifthly, seek legal advice. If all else fails, consult with an attorney to explore your legal options. A breach of contract occurs when one party fails to fulfill their obligations as outlined in a contract. The elements of a breach of contract are: firstly, a valid contract must exist. Secondly, one party must have failed to perform their obligations. Thirdly, the breach must have caused damages to the other party. Common remedies for breach of contract include: firstly, damages. The non-breaching party may be entitled to monetary compensation to cover their losses. Secondly, specific performance. The court may order the breaching party to fulfill their obligations as outlined in the contract. Thirdly, rescission. The contract may be cancelled and the parties restored to their original positions. Fourthly, reformation. The contract may be rewritten to reflect the parties' original intentions. To prepare for potential payment issues, firstly, conduct due diligence. Before entering into a contract, research the other party's financial stability and reputation. Secondly, include a clear payment clause. The contract should clearly state the payment terms, including the amount owed, due date, and consequences of non-payment. Thirdly, obtain insurance. Consider purchasing insurance to protect yourself against losses due to non-payment. Fourthly, maintain good communication. Keep open lines of communication with the other party to address any concerns or issues that may arise. Fifthly, be prepared to take legal action. If necessary, be prepared to pursue legal action to recover the debt. Regarding post-closing agreements, these are agreements made after a real estate transaction has closed. They typically address issues that were not resolved during the closing process. Common provisions in post-closing agreements include: firstly, repairs or renovations. The seller may agree to make certain repairs or renovations after the closing. Secondly, escrow holdbacks. Funds may be held in escrow to cover potential costs or liabilities. Thirdly, access to the property. The seller may retain limited access to the property after the closing to retrieve personal belongings or complete certain tasks. Fourthly, dispute resolution. The agreement may outline procedures for resolving any disputes that may arise after the closing. To ensure a smooth closing process, firstly, hire a qualified real estate attorney. An attorney can review the contract, advise you on your rights and obligations, and represent you at the closing. Secondly, conduct a thorough inspection. Have the property inspected by a qualified professional to identify any potential issues. Thirdly, to obtain title insurance. Title insurance protects you against any defects in the title to the property. Fourthly, review all closing documents carefully. Before signing any documents, make sure you understand them completely. Fifthly, attend the closing in person. This allows you to ask questions and address any concerns you may have. When you are considering the legal recourse for non-payment, you should understand: firstly, small claims court. This is a simplified court process for resolving disputes involving small amounts of money. Secondly, mediation. This is a process where a neutral third party helps the parties reach a settlement. Thirdly, arbitration. This is a process where a neutral third party hears both sides of the dispute and makes a binding decision. Fourthly, lawsuit. This is the formal legal action filed in court. Before taking legal action, consider the costs and benefits. Legal fees can be expensive, and there's no guarantee of success. Also, consider the time and effort involved in pursuing legal action. Firstly, gather all relevant documents. This includes the contract, invoices, payment records, and any correspondence with the other party. Secondly, consult with an attorney. An attorney can advise you on your legal options and represent you in court. Thirdly, file a complaint. The complaint is the document that initiates the lawsuit. Fourthly, serve the defendant. The defendant must be formally notified of the lawsuit. Fifthly, attend court hearings. You may be required to attend court hearings and present evidence in support of your case. Understanding these concepts and implementing these strategies can help individuals and businesses protect themselves from the risks of non-payment and ensure they receive the compensation they are owed. Always seek professional legal and financial advice when dealing with complex transactions or potential disputes. By taking proactive steps and understanding your rights and options, you can minimize the risk of financial loss and maintain a strong financial position. Remember, thorough preparation and clear communication are key to avoiding payment issues and ensuring a successful transaction.